Yeah, so anytime you're charged with a domestic violence crime or the court believes that there's probable cause for domestic violence crime, they're going to require you to complete a firearm affidavit. What that means is that you have to sign a form that says you either own no firearms or that you've relinquished this firearm or transferred it to another individual. That's just because whenever you're under investigation for a domestic violence crime or charged with one, you're not allowed to possess a firearm. If you don't comply with this affidavit, or if the prosecution is able to find out that you were lying on this affidavit, you can face new charges such as a violation of protection order or other charges and consequences if you don't complete the firearm affidavit or if you're not complying with it. Another unique circumstance you often find with domestic violence crimes is a mandatory protection order. So statute requires that a mandatory protection order be issued anytime that there's a domestic violence crime. Often this mandatory protection order makes it so that you cannot contact, harass, molest, intimidate, or live in the home with the person who is said to be the alleged victim. Often you need a lawyer to help you in modifying this protection order that can allow you to go back home or have contact or things like that. The third circumstance is going to be that the prosecutor has full discretion in continuing to press charges. So oftentimes in domestic violence, just because the alleged victim does not want to press charges anymore and says that they want the case dropped, that does not mean that the prosecutor drops the case. The prosecutor goes off the evidence they have, and while they'll consider the fact that that person doesn't want charges to be pressed anymore and that they want the case to be dismissed, if the prosecutor believes they have sufficient evidence to continue forward with the case, they'll continue to prosecute it no matter what the alleged victim wants.